23rd. Prosecutor and defense, is everyone here for yourselves, for your cases?
Your Honor, for the prosecution, one Lucifer McCalister is not present.
Is he in the city?
That I'm not aware of. According to the my sources, my paralegal, it is hard to say where he is.
Interesting. I do believe you have somebody behind you with their hands up.
Yes, Your Honor. I believe Lucifer is incredibly sick and he's having treatment outside of the city for the time being.
All right. Okay, fine. That's fine. I'll note that down. Mr. Squiggs, everyone here?
Yes, Your Honor. Defendant here, paralegal here, and myself here. We are all set.
Awesome. Wonderful. So just a few rules. No yelling, screaming, throwing hissy fits, no walking out of the courthouse. Everybody will be respectful. I expect only the best from the finest here in the room.
Absolutely, Your Honor.
All right, I'm going to call this court into session. District Court of San Andreas. This is the State of San Andreas versus Bobby Nubbz. This is case 21-17075. State Prosecutor, if you would please read the charges.
Yes, Your Honor. 1 times PC 2233, assault with a deadly weapon. 1 times PC 2104, attempted murder.
Okay, they're very similar charges. All right, defense, how does your client plead?
Not guilty, Your Honor.
All right. Well, with that set, we'll go ahead as usual with a classic court case. So, Prosecutor, the floor is yours.
Yes, Your Honor. May I approach the well?
Yes, go ahead.
Thank you. Your Honor, ladies and gentlemen of the court, my name is Harvey Blackstone. I am the Assistant District Attorney for the State of San Andreas. On September 9th, 2021, here outside the Sanctuary of Justice, the defendant did a horrendous and heinous act by stabbing one Luke Smith, and noted in Exhibit H, had the audacity to claim it was self-defense. Today we'll be discussing what led to these charges and how, without a shadow of a doubt, the defendant will be guilty. That's all, Your Honor.
Thank you. And defense, Mr. Squibs?
Thank you, Your Honor. May I approach as well?
Always, yes.
Your Honor, members of the court, my name is Mick Squiggs, and I'm representing Mr. Bobby Nubbz this evening. Mr. Nubbz was arrested on September 9th. He was subsequently charged under Penal Code 2233, assault with a deadly weapon, and the later added charge by the DA's office, Penal Code 2104, attempted murder. The evidence presented today will show that on September 9th, Mr. Nubbz was using his right to defend himself during a hostile encounter. Self-defense, as most things in the court of law, is not black and white. It comes down to a number of specific elements. Some of these elements, but not all inclusive, that must be examined during this trial are: first, was it an unprovoked attack? Second, were there threats of imminent injury or death? Third, was it an objectively reasonable degree of force to an objectively reasonable fear of injury or death? Mr. Nubbz is a civilian of the state and not trained in any sort of hostile scenarios. Yes, he may have been breaking some traffic laws, but he was absolutely not violent at all until he was approached, threatened, and attacked by individuals unknown to him. He feared for his life and protected the only way he knew how. During the course of this trial, the state must prove beyond a reasonable doubt that my client is guilty of these specific charges. The definition of PC 2233, assault, is a threat of bodily harm with a dangerous weapon coupled with an apparent present ability to cause harm. In the case where the threat is made against a group, only one charge will be presented, etc., etc. Really, the only part that matters is that first line. The court must ask itself why my client was given this charge, when it specifically states that if a weapon is used with the intent to cause harm, it would be felonious assault. For clarity, this means that he's been charged with the threat of using a weapon and not the actual act of carrying it out. This leads me to the second charge, PC 2104, attempted murder. I won't read the entire definition, but the first part reads, when a person intentionally takes steps to kill a person, or when they intentionally cause a person to be incapacitated. This means the state must prove beyond a reasonable doubt that my client had the intention to have taken someone's life. He must have thought about it, planned it, knew that was his goal. The defense requests the court ask themselves two questions during the trial. First, if the state did not charge my client with felonious assault and instead opted for the threat of assault, how can they possibly believe he can be charged with attempted murder? Second, does it make more sense that my client decided to just pick up, head to a location, cause a scene in order to attract a specific individual to kill, or that he was merely breaking some traffic laws and when others escalated, he became fearful and reacted in self-defense? Thank you.
Thank you, defense. All right, prosecution, you may call your first witness.
Yes, Your Honor. I'd like to call this stand 1X95 McLane.
Mr. McLane, if you would come to your left to the bailiff, please.
Yes, Your Honor.
Mac McLane, can you please raise both hands? Do you solemnly swear to affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Will you please stand next to Miss Judge Ruby York there to the right and speak into the microphone?
Mr. Blackstone.
Yes, Your Honor. Hello there, Supervisor Deputy Marshal McLean. How are you doing today?
Outstanding, sir. How about yourself?
Doing fantastic. I'm sorry we had to. This is what brought you here today. How long have you served as an LEO in general?
I've been a law enforcement officer in the state of San Andreas since February.
Okay. In regards to what happened back on September 9th, is this type of incident something you're experienced in handling?
Yes, I've investigated a number of assaults.
Okay. Is that you in exhibits A1 and A2 taking pictures of the crime scene?
Yeah, just give me one moment to pull that up so I can answer correctly here.
Sure. Yeah, take your time.
Yes, I was the person taking those photos in Exhibits A.
Okay. Were you present at the courthouse when this incident occurred?
I was inside the courthouse at the time the stabbing occurred.
Okay. Alrighty then. Let's see here. In Exhibit B, you're the one who searched his pockets, correct?
Yes.
Okay. And that was in Exhibit C, that was you who did the fingerprint scan.
Correct.
Okay. Now then. Jumping down to Exhibit H. Is that your body cam?
Yes, it is.
Okay. In Exhibit H, did the defendant identify himself to you, meaning his first and last name?
Yes, he said his name is Bobby Nubbz.
Okay. Of course, in the Exhibit H at 54 seconds, you can see that McLane did fingerprint the defendant. Now, let's see here. Okay. Did the defendant wish to continue to speak to you after you Mirandized him?
Yes, I was able to interview the defendant in this case.
Okay. Did the defendant admit that he stabbed Luke Smith?
Yes, he said that after Luke Smith had punched him, he took out a knife and then proceeded to stab Mr. Smith.
Okay. Alrighty. Make sure here. And that you can see on Exhibit H at 2 minutes 3 seconds, Bobby Nubbz is explaining what happened in the situation backed by Exhibits E, F, and G. And let's see here.
Your Honor,
Ooh.
I'd have to object. Was that a question?
Yeah, can you speak up,
Yeah.
sir?
Yeah,
Oh,
my
sorry, Your
apologies.
Honor. I have to object. There wasn't really a question in there.
I'm leading up to a question, Your Honor.
All right, go ahead and ask the question then, please.
Yes. What did Bobby Nubbz admit to his reason for stabbing the victim?
He stated that he stabbed the victim because Luke Smith, I'll just use their names if it's easier. Bobby stated that he stabbed Luke Smith because Luke Smith punched him, Bobby.
Okay. Again, that can also be found at 2 minutes 11 seconds. Okay. Why did the defendant admit to you it was self-defense?
That's what he was trying to say, is that because Luke punched him in the face, he thought he was within his right to proceed to stab the victim because he was simply punched in the face.
Okay. And in your professional opinion, as a law enforcement officer, is that typical for someone to do that?
Usually we don't get many assault cases where someone, after they get punched, just pulls out a knife and proceeds to stab someone. No, we don't get many of those cases.
Okay. Did the victim have to be rushed to the hospital?
If I can refer to my report real quick, if you don't mind.
Go ahead.
Okay. I actually don't recall if hospitalization was required in this case. When I responded out to the scene of the stabbing, Foxhound Solutions already had one person detained. There was a lot of flashing lights outside. I just remember that after a couple of minutes, I don't know if he had already gone to the hospital and came back or not, but I was able to speak to Luke Smith after the scene was secured.
Okay. All right then. No further questions, Your Honor.
All right. Yeah, you can step back and Mr. Squiggs.
Thank you, Your Honor. Detective McLane, you stated in that questioning that Mr. Nubbz identified Luke as the individual that attacked him. In reviewing evidence, believe it's D1 at this point, just the body cam footage, referencing 2 minutes 03. It appears he actually said he did not know. Can you please clarify for me? Did Bobby Nubbz identify Luke Smith at any point?
Give me a second to review the portion you're talking about. I know.
Absolutely.
Yeah. Yeah. Give me 1 second. In the body cam, he does state that he said he doesn't know who it was. I had identified Luke Smith on scene. It was just easier for me because we're dealing with two males, just to refer to them by name during testimony.
Absolutely. Yeah, just wanted a clarification on that. Appreciate it.
Of course.
And also for clarification, you were not present at the crime scene itself, correct?
I was present at the crime scene. I did not witness the actual stabbing. I got there. I responded to a report of a stabbing, so it was already concluded by the time I got there.
Okay, thank you. And for, again, clarification, I'm a stickler for it. You stated that Bobby's response to you when asking about the cause was he said he got punched from the back, correct?
I believe that's what he said. He was punched in the back of the head.
Okay, thank you. No further questions.
Prosecution, did you want to re-examine or?
Let's see here.
With any question that has not already been raised?
Bear with me 1 moment, Your Honor. No, Your Honor, I have no further questions.
All right, thank you, Mr. McLane. You may sit down.
Yes, Your Honor.
All right, prosecution, your second witness.
Yes, Your Honor. I'd like to call to stand Maeve CollyMore. Maeve CollyMore.
Miss CollyMore, if you would come towards the bailiff on your left, please.
Thank you, Ms. CollyMore. Can you please raise both your hands? Do you solemnly swear or affirm that the testimony you are about to give will be the whole truth, and nothing but the truth, so help you God?
I do.
Please take a seat next to the Judge Ruby York there and speak into the microphone.
Mr. Blackstone.
Thank you, Your Honor. Excuse me. Hello, Ms. CollyMore.
Hello.
How are you doing this evening?
I'm doing perfect. How are you?
Doing well. Ms. CollyMore, for clarification for the court, what is your occupation?
I am Medic 50 from the LSFD and team leader of Foxhound Solutions.
Okay. On September 9th, 2021, what were you doing that evening?
I was working a shift at the courthouse. If I recall correctly, there were multiple court cases. So I was standing here guard as well as positioning other guards around the courthouse inside and outside.
Okay. All right. And let's see here. Just taking a look at something here, y'all.
Take your time.
Do you know the defendant?
I've seen him a few times. I only knew his name after the incident. But
Okay.
personally, no.
Did you know the victim?
Yes. Mr. Smith likes to hang out around us, or around the courthouse in general, not around us as Foxhound.
All right. And according to your statement here, did you know a Mr. Jared Evans?
Yes, I knew him because of me being around the courthouse, and he is a paralegal.
Okay. All right. Did you witness Did the defendant stab the victim?
Yes.
Okay. Make sure I'm asking the right questions here. All right. Did the defendant show any reason to stab? Or did did the defendant show any reason to stab the victim?
He claimed afterwards that it was in self-defense, that he was yelling, he punched me first.
Okay. Was the victim incapacitated?
Yes.
Okay. And going back to your occupations, you also say you work for the LSFD. What is your occupation in the LSFD?
I'm a paramedic.
Okay. What trainings do you have? What qualifications do you have as a paramedic as far as dealing with stabbed victims?
To my personal training, as of this moment, I can stabilize the person, make sure they're bleeding, make sure their wound is cleaned, and then I have to transport them to the hospital for stitches.
Okay. Did you see where the victim was stabbed?
I believe once in the stomach and once in the back, if I can recall correctly.
Okay. All right. For clarification, though, I know it's a little bit ways to think about and not really something to dwell on. Do you know for sure where he was stabbed?
Yeah, I believe it's in the stomach and in the back because when Mr. Nubbz first struck, it was face to face, and then Mr. Smith tried to move away, so he turned his face around he turned around entirely, and Mr. Nubbz hit him in the back as well. Then he got incapacitated.
Okay. So Mr. Smith was trying to get away from the defendant.
After the first strike, yes.
Okay. Interesting. You said he was stabbed twice before being
Yes.
incapacitated? Oh, my apologies.
Your Honor, I'd have to object to that. That's leading.
It is leading. So, Mr. Blackstone, if we could have some direct questions, please.
Okay. All right. With your medical professional opinion, being stabbed in the back and the stomach, are those lethal?
If not treated in... Sorry, I'm trying to find the right words. It could be lethal, yes. It needs immediate attention.
Okay. All right. What organs would be endangered? What organs were endangered in the stabbings?
The kidneys and the liver.
Okay. And those are, which one of those is vital?
I could say the kidneys are definitely vital because kidney failure most of the times can lead to fatal situations.
Okay.
Oh, but you only need like one kidney.
Did the victim lose quite a bit of blood?
Just a little bit, as soon as I got Mr. Nubbz detained, I immediately turned my attention to the victim.
Okay. Alrighty. Did the victim require hospitalization?
As in, stay in the hospital?
Or having to go to the hospital for treatment?
Yes.
Okay. All right. how was the defendant dealt with after Mr. Smith was stabbed?
Now, I was the highest ranking at the scene in Foxhound Solutions, therefore I took lead. I immediately approached Mr. Nubbz and I said on the radio to my other guards to be less than lethal due to me witnessing Mr. Smith strike first. So as soon as Mr. Smith fell to the ground, Mr. Nubbz put his knife away, looked in my direction, said he attacked me first, and he put his hands up as I instructed him to. And I slowly approached him from behind, put him in handcuffs, and helped him to the sidewalk.
Okay. Just make sure I'm going through everything here, Your Honor. All right. No further questions, Your Honor.
All right, thank you. Mr. Squiggs.
Thank you, Your Honor. Oh, sorry. Go
Excuse
ahead. Yeah, go ahead. You're good. All right. Is it Officer Maeve or what do you? Is there a? How do you like to be called?
Just Maeve.
Maeve. Okay. All right. Nice to see you, Maeve. Appreciate you coming down.
Likewise.
I'm gonna get just, a few quick questions. We won't go into an anatomy lesson or anything like that. But at the beginning of your statement there, you brought up a specific threat that was made to the defendant. Do you remember what was said?
I did not witness it, but as soon as I approached the situation where Mr. Nubbz had a vehicle illegally parked on the crosswalk in front of the courthouse, he told me that Mr. Evans threatened him to shoot him if he doesn't move his car. And when I asked Mr. Evans, like, why are you doing this? He said,
Your
it's a
Honor,
joke.
I'd like to object to that. That's hearsay, because it's coming from a person to another person to Ms. CollyMore,
It was directly said to her.
but it was not said by Mr. Evans.
It
It's not
was
hearsay.
said by the defendant, correct?
Right.
So the defendant spoke to Miss CollyMore?
Correct.
But based on what Mr. Evans had said.
Well, well, so far we're until we hear from one more witness, hopefully. That is exactly what we're hearing so far. I'm just gonna overrule that at the moment. If you would continue, Mr. Squiggs, with the question here, please.
Absolutely, Your Honor. Maeve, in your professional opinion, as stated by the state, with Foxhound Solutions, I believe that's the name of it. Correct me if I'm wrong. If you are threatened with a lethal weapon, how would you respond?
As a security guard, if I had threats on me with a lethal weapon, if I see the person who's threatening me, I would keep my hand on my gun.
Objection, Your Honor. This is coming from a security guard, not from a civilian's perspective. This is coming from a professional's perspective, rather than just an average citizen, which would have different training and qualifications. I'd ask it be that statement be stricken from the record.
In regard to exactly what that Miss CollyMore said.
About her opinion as to how she would react. The question.
Mr. Squiggs, what was your question again?
And my question was related to the state's introduction of her professional record. I asked her, based off that, how she would respond to already established threat of being shot.
I'm actually going to sustain that, actually. If you would, I think we're going to move on from that portion of her response to that.
Okay.
Yeah, I believe that's the right thing to do.
Okay. Thank you, Your Honor. Then we'll move away from that. Maeve, just so for clarification purposes, Bobby Nubbz, the defendant, told you that he had been threatened with a gun.
Correct.
From that point, did you see Bobby pull out a weapon at that time?
Negative.
At what point did you see Bobby pull out a knife?
As soon as Mr. Smith got on top of the car behind him and punched him in the back of the head.
Did Mr. Smith and Bobby have any interaction before that incident?
I don't believe so. I see them around the courthouse like coexisting, but I never saw them interacting together, so I couldn't tell.
Okay. Appreciate the answer. Thank you. Previous name Jared was brought up. During your approach of Bobby, was Jared in your vicinity? Did you have any interactions with Jared whatsoever?
Objection, Your Honor. That's a compound question.
Did you have any interactions with Jared?
Yep. Hold on. So, yes. Sustained. So just
So, Your Honor, I'll only ask
Yeah.
one question.
okay. Would you just repeat the question, please?
Absolutely. Did you have any interactions with Jared?
Yes, I did.
Did you have interactions? Okay, hold on. So I'm gonna reword this. I apologize. After your interaction, after Jared threatened him with a gun, did you have any interactions with Jared after the fact?
Yes, I told Mr. Jarrett to step away because we are guards and we're gonna deal with the situation.
And did Jared step away?
Yes, he did.
And at that point, how many individuals were near Bobby?
It was me, my guard Lucifer, and Drew Gaynor. And Mr. Smith was behind me.
And did Bobby say anything at that time?
Negative. I asked him to move his vehicle out of the crosswalk, and he got on top of it.
So, but no response at all. No, nothing at all.
I honestly don't recall.
It's okay. No, it's all right. So, after he was threatened by Jared, a group, as according to you, were near the vehicle with no response from Bobby. Is that correct?
I believe so, yes.
Thank you. All right. At that point, at what point does Luke attack Bobby? I apologize. I'll actually reword that. At what point does Luke punch Bobby?
When I asked when I asked Bobby to move his vehicle, Mr. Nubbz got on top of his vehicle. Then Mr. Smith circled around, got on top of the vehicle behind him, and punched him in the back of the head.
So it was once everyone was near the vehicle.
Once Evan stepped away from the vehicle. Oh, sorry. He got on top of the vehicle behind Bobby, said, he yelled at him, "Move your vehicle," and I think he used a bad word, which I'm not going to say, and punched him in the back of the head.
Appreciate it. Thank you. Just give me 1 second here. I have one last notation. Okay, I apologize. I was taking notes from the previous questioning. I apologize. You stated that Luke turned away from the defendant after the first. And is there any clarification? I guess, was he stabbed or punched the first time before Luke moved away? So the specific question is, was it a punch or a stab before Luke moved away?
Mr. Nubbz did not punch at all. As soon as he was punched, he said, "You're getting stabbed," and instantly pulled out his knife and stabbed him twice.
Okay, so he responded. Or sorry, how did he respond? Again, for clarification purposes, how did he respond to getting punched in the back of the head?
Objection, Your Honor. Asked and answered.
Mr. Squiggs, are you looking for an action or are you looking for character?
Clarification to the state's questioning about the moving away portion.
Of which she already answered.
Give me 1 second to check my notes. In regard to Luke and Nubbz being on top of the vehicle, for clarification, Miss CollyMore said that he did not move away after the punch.
Man, I gotta go. This shit right up my ass.
Yes, Ryan. That's what I was trying to get
Yes.
Right up my ass. Bro. I gotta.
Was there another question? That's what she said previously.
No, actually, yeah, no. If that's what you no, actually, that's where I was getting. If that's been asked and answered, then I have no objection. Or sorry, I have no
Yes.
response.
Yeah, he did not move away after the punch.
Okay, no, appreciate it. Thank you. All right, that's I'm all right with that.
Is that correct, Miss CollyMore?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Any more questions, Mr. Squiggs?
Just one last one, Your Honor. Maeve, did you know Bobby in any way, shape, or form before this incident?
Negative.
Your
I've
Honor,
only
objection. Again, that was asked and answered before.
I
the
believe
question-
that was. It was. Sorry, go ahead.
If I may,
rebuttal.
specifically, he asked if she's seen Bobby around, not if she knew Bobby.
Your Honor, I believe I asked, does she know the defendant?
Okay, so that's two different questions, knowing and seeing. So therefore, in regard to the prosecutors, did she know Bobby? We will sustain on that. Do you want to ask a different question, Mr. Squiggs?
No, if that's actually no, I'm good actually. If that was already asked and answered, I just need
Yes.
that on the record. All right, appreciate it. All right, then yeah, no further questions, Your Honor.
All right, thank you.
Thank you.
Were there any questions that were not that you have, Mr. Blackstone?
Yes, Your Honor. Ms. CollyMore. Let's see. Actually, Your Honor, for clarification, did I ask if he knew, or if the witness knew Jared Evans? I want to make sure I'm not going to.
Wait, Your Honor, I have to object to
Well,
all of this. Cross-examination is not new questions.
It's not a sorry. It's not a new question. It's a clarification of what the defense, or a question in regard to what the defendant has asked the witness.
Okay, Your Honor. My apologies.
And I do believe Miss CollyMore has already spoken in regard to Mr. Evans.
Okay. All right. In regards to the supposed threat that Mr. Evans said, did you see Mr. Evans at all pull a gun?
Negative.
No further questions, Your Honor.
Okay. All right. Thank you, Miss CollyMore. You may be seated.
Thank you, Your Honor.
I just want to remind the court to please eat and drink. Don't forget your vitals.
Your Honor, in regards to Mr. McCalister, Exhibits
Mhm.
E, am I able to read that for the court? Being he is not present.
Give me 1 second, please, to just pull that paperwork up to look at it first.
No.
After you check it, Your Honor, I'd like to have a chance to reply to that request if you.
Yes.
If you
Yeah, I have it before me. Go ahead.
I'd
Defendant.
absolutely object to reading out the statement. There's no notification on the docket about a witness not showing up, thus not allowing the defense time to depose the witness if they're not available. What that would allow in this court is a statement that the defense can't question, can't cross-examine, can't do anything about it. If the witness had given notification to the state, would have allowed us time to reach out and depose or get some sort of legal cross-examination going. A last-minute no-show and reading off a statement doesn't seem very legal to me.
Your Honor,
Yes.
may I rebuttal?
Go ahead.
Defense was given 6 days, and well, actually, let me clarify real quick for that.
So while you're looking at that, let me read something out. That it says that first-hand witnesses that cannot attend the trial must provide a statement. Now, you provided them even though we did not know if they were attending or not. And as of this evening, when the court did start, we were not made aware until court was in session that unfortunately Mr. McCalister is ill. I do agree that there was no chance for the defense to even email questions to the individual because unfortunately, and nothing, I'm very sad to hear that Mr. McCalister is not feeling well. However, there wasn't a chance for the defense to question his statement.
But, Your Honor, it was noted on Friday at 1:51 a.m. that these statements were put on there. That gave the defense a few days to come up with any ideas or be able to reach out to the witness to be able to question him. They had plenty of time, Your Honor, during discovery.
I did not see Mr. McCalister say that he was unable to come, though.
Okay. All right, then, Your Honor. I will then withdraw my request to read the statement.
At this time, do you have any other witnesses, sir?
No, Your Honor. Prosecution rests.
All right. Mr. Squiggs, the floor is over to you, sir.
Your Honor, we have no further witnesses. And without any further, I think the defense rests as well. We would request a 5-10 minute recess. Just to go over.
I'm going to give a 5-minute recess for everyone to stretch their legs, for the defendant and prosecutor to go ahead and put their, the last shiny parts on their closing statements. So we will re-adjourn in 5 minutes from now.
Thank you, Your Honor.
Oh, shit.
Ooh.
The district court is back in session. The Honorable Judge York still presiding.
All right, ladies and gentlemen, you may be seated. We are going to move into closing statements. Mr. Blackstone, the floor is yours.
Okay, Your Honor. May I approach the well?
You can approach anything on the floor.
Thank you,
Chairs
Your
are
Honor.
lava.
Okay, I'll keep that in mind, Your Honor. Alrighty. Your Honor, ladies and gentlemen of the court, let me first thank you for your time and attention this evening. Before you leave to begin your deliberation, please remember the testimonies of Mac McLane, the arresting officer, Maeve CollyMore, the witness to the stabbing. In questioning, we heard here that the actions made by the defendant were excessive, heinous, and horrendous with his actions. Sir. The victim, Luke Smith, was brutally stabbed, not once, which can be understandable, but twice, as Luke Smith, as from the account by Ms. CollyMore, was turning away, and was stabbed in the back in his kidney. Given with exhibits A1 through 2, you can clearly see there's been bloodshed on the ground. And that's not blood from being hit from the back of the head, as for what was apparently happened. No, this was caused by a knife. However, with the punch, it was never defined as how hard he was punched. Understanding it only takes contact for assault. In Exhibit B, what reasonable person would carry 3 knives on them? 3. It wasn't just one knife. It's understandable if it was one knife. Maybe that could be more argued. But with 3, it's a little bit excessive.
I ain't got a house. Where else am I supposed to put them?
The defendant, from Maeve CollyMore's account, said to the victim, Luke Smith, "You're going to get stabbed now." After being stabbed twice, Luke Smith was rendered incapacitated and required other medical care by going to the hospital, which is defined in attempted murder. That it takes a person to be incapacitated to count as attempted murder. And understanding what the defense was trying to push forward as far as attempted murder goes, remember, there are 3 degrees of murder. First, which is, it has to be thoroughly planned out. Second, which is the unintentional causing, which was harm, but leading to the intentional cause of death. And then, of course, we all know third-degree manslaughter, which is the accidental death of a person. Or, yes, of the death. However, in regards to that, once again, he was put in the hospital, which is defined in that law. That's why the DA's office saw it necessary to put it on, to charge it to the defendant. Now, as far as this assault with a deadly weapon, he had a knife out when there was, as from what was defined, a group of people around him. Again, a threat, as what was defined in the law. Bear with me a moment, yeah. Again, with the threat of bodily harm with a dangerous weapon, with the apparent present ability to cause harm. That means having the knife out. Having that knife out, that is a present ability to cause harm. That's why that's proven right there with all those with the testimony of both witnesses, or the testimony of the arresting officer and the testimony of the witness. That can be shown that way. It was also noted that Mr. Evans, who was the one who supposedly, from only the defendant's account, from the defendant's mouth, said he was threatened. However, as from the testimony of Ms. CollyMore, Mr. Evans never pulled a gun. With that, as far as his reason for stabbing Luke Smith, for again, Jared before Mr. Smith was stabbed. What other reason does Mr. Smith have to be stabbed? It is proven with that, Your Honor. It's proven without a shadow of doubt. This defendant should be proven without a shadow of doubt guilty of assault with a deadly weapon and attempted murder. That's all, Your Honor.
Thank you, Mr. Blackstone. Mr. Squibs, go ahead and give your closing statement, please.
Thank you, Your Honor. Your Honor, we appreciate your attention throughout this matter, and we thank you for listening to both sides equally. In the case today, the state has presented insufficient evidence to convict my client of PC 2104, attempted murder, or PC 2233, assault with deadly weapon. We are not debating the actions that occurred, but the reasons for them. Intent is a major part of these charges. Charges that, again, are the responsibility of the state to decide based off of the incident. We have heard from Detective McLane and Maeve about this incident. Detective McLane has testified to the fact that Bobby did not know Luke during questioning, and in fact testified that Bobby stated he responded to an assault. If Bobby had the intent to murder Luke, we have to ask, how did he not know him? Maeve has testified that a Jaron Evans threatened Bobby. Specifically, she stated he threatened to shoot him. This is a lethal threat. He's not required to wait to be shot. Bobby was then surrounded by a group of individuals unknown to him and attacked from behind. He responded fearing for his life. These are not uniformed police officers that he would have known on sight. This is not to downplay the important role. This merely means that if Foxhound is unknown to the individual, that individual may not know they are security for the courthouse. Bobby did not attack anyone other than the person attacking him. He did not have any intent to cause harm. He just wanted to live. The state failed to prove that my client had any intent on harming anyone. He was reacting to an escalating situation, a bad situation, but he is here today to clear his name and find justice. We would ask you to render the only verdict that is fair, not guilty. Thank you, Your Honor.
All right. Thank you, Mr. Squibs. Court will be in recess for 2 minutes. If you would just stay within the courtroom, please.
I'll be right back.
All rise. District Court is back in session. The Honorable Judge York still presiding.
All right, ladies and gentlemen, you may be seated. Mr. Nubbz, if you would please stand. Thank you. Well, ladies and gentlemen, this has been a very interesting case. And I'm sure that many of you are thinking, what defines self-defense at this point? So I'm just going to talk a little bit first before I give my final rulings here. Here we go. So, do we look at the testimony given from Miss CollyMore and the testimony given by Mr. McLane? And do we hear in those testimonies the declaration by Mr. Nubbz that he was punched first? Do we also listen to the testimony that was given that Mr. Nubbz said, "Now I'm going to stab you"? And how do we balance those two with the laws that rule our land? It's one thing to say, "I'm going to shoot you." It's another thing to say it and then pull out a firearm. So, in regards to PC 2104, attempted murder, Mr. Nubbz, I find you not guilty. Now I'm going to speak to the second charge of assault with a deadly weapon.
Aye.
All right, so knives in our state are considered deadly force weapons. and they should only be used in situations where the individual believes that he or she is in great danger of bodily harm. Without the presence of the first threat of a firearm, with the presence of the unbeknowing blow to the back of the head, I believe that Mr. Nubbz escalated the situation by pulling out a knife and clearly stating to Mr. Smith that he was going to stab him. Because of that admission, because of the witnesses' statements that stated that Mr. Nubbz said that, in regards to assault with a deadly weapon, Mr. Nubbz, I do find you guilty. At this point, court is adjourned. If you have any questions, you are more than welcome to come and speak to me. Thank you, ladies and gentlemen.
Thank you, Your
Thank
Honor.
you, Your Honor.
Your Honor, sentencing?
No.
Oh.
I
Mr.
believe
Nubbz,
that
stop.
he has.
Bobby.
No, he
hold
was
on a
out on
minute,
bail,
Mr.
Your Honor.
Nubbz.
No.
Yes.
Mr.
Bobby.
Nubbz, stop.
Stay still, Mr. Nubbz, please.
Hands behind your back.
I already served this.
You were out on bail. Turn around.
And then I got a violent
Turn
charge.
around, or I'm going to arrest you right now.
You already are.
You're under arrest. Turn around,
All
Bobby.
right.
Just to be clear, you're under arrest for a new charge at this point once you get done here.
For what?
All right, ladies and gentlemen, you're free to go. I'm going to be speaking to the defendant and his client. If I could have some law enforcement to stay, please. Let me just let me look at these charges again. Okay, or else feel free to all stay if you'd like. That's great.
I'm intrigued.
All right, so Mr. Nubbz, you were released on bail. However, the second charge was not guilty. The first initial charge was guilty. You have been rather compliant until this last minute. So I am going to give you 30 months in Bolingbroke Penitentiary. You will be forfeiting your bail. And we will be charging you with a $5,000 fine.
Your Honor, if I can make
Yes.
a statement here. The body cam footage clearly shows he was in custody for a certain amount of time. We'd request time served for that.
I already got charged.
Bobby.
And as for the incident that just occurred, Your Honor, you did state that people were free to go. This is not a
Yes.
critique on you. I believe the
I
client
understand.
heard that and did not mean any defiance by it.
So usually it's 45 months and a $15,000 fine. So at this time I'm bringing it down because I realize not just because of good behavior, but because of the time that he spent. I do believe that 30 months is a fair amount of time for the crime done. And I believe that forfeiting his bail, therefore a $5,000 fee is, and I already know that the state, of course, will end up covering that due to bankruptcy. So 30 months and a $5,000 instead of 45 and 15,000.
Just 1 minute. This is for the assault with the deadly, right?
Correct.
I already served time for that.
You
They stacked
were
it on
released?
top. Yeah, but then I got a violent felony, and when I got arrested
A
for
second time?
yeah, they gave me like it was the one with 120 months.
He was, Your Honor, due to the way the bail works, he was arrested afterwards and had to serve time for both charges after that.
All right, give me one moment. Unfortunately, Mr. Nubbz has so many arrests that it's hard to go through them all.
It's not my fault.
Uh-huh. Can I speak to Mr. McLane up here, please?
Yes, Your Honor. His original arrest has fallen off because there are so many. He does have one charge from the 15th for assault on a public servant, but there's no mention of them adding anything additional for a bail violation. He's just been arrested so many times since he was out on bail that it could be lost.
It was the one where the heads of all the departments arrested me.
Yeah, that's not even on his record anymore.
Fuck. Damn, I think they fall off a little too quickly. Attempted murder.
All right, Mr. Nubbz. Our records are default only so that we can see the latest 5 records. So therefore, because I cannot see where those charges were added on top of that, I'm going to take you at your word and I'm going to hope that you are not lying. I am going to ask the government to give me your full charges from beginning to end of your lifetime, and I'm sure it's going to be long and extensive.
You're gonna get a book.
And I'm going to look all the way through. And Mr. Nubbz, if you're lying to me and that in fact you did not serve your time on top of your arrest that came after that, then I will be holding you with perjury in court.
Aye.
So last chance, well, not last chance, but once again, are you telling me the truth that you have served your time and fine?
Yeah.
All right. At this time then, gentlemen, I'm going to release Bobby Nubbz into the care of his lawyer. Tomorrow, hopefully, I will have his full charges. I will submit those to your lawyer, and if you are telling the truth, then we will not be putting out any kind of arrest warrant. If you're not telling the truth, then an arrest warrant will be issued. Is this understood?
Yep.
Yes, Your Honor.
Your Honor,
Yes.
from prosecution, what about the $5,000 fine?
Well, he would have been fined as well. So I'll find out. Let me deal with that and deal with his lawyer tomorrow.
The fines don't
Okay,
matter.
Your Honor.
The fines don't. Why don't the fines matter?
I'm like 75 grand in debt.
Yes, you are indeed.
Although, Your Honor, if I may rebel to that, This city
Yes.
does. This city does have asset reclamation.
I own a bicycle.
I feel like that's a separate thing, Your Honor.
It is a separate thing, but it's worth a little bit of a giggle, isn't it? So yes,
Sure.
Bobby Nubbz owns a bicycle. So I suppose the city could get their $200 back for the bicycle if they really wanted
I didn't even buy it.
Okay, fantastic. It's still worth $200, sir. All right, ladies and gentlemen, you're free to go this time. Mr. Nubbz, you are being released into the care of your lawyer for the next 24 hours.
Thank
All
you, Your
right.
All
Honor.
right. Thank you.